Good morning, sir. You're Larry Williams?
Yes, ma'am.
And so we've got two cases with Mr. Williams. Cause number 25 DCCR 0985. Mr. Williams is charged with capital murder. And Mr. Cashin, you represent him on that case.
Yes, Your Honor.
Mr. Johns was hired to represent Mr. Williams in cause number 24 DCCR 1790, which is the aggravated assault causing serious bodily injury.
Yes, ma'am.
We're here today on an announcement. Mr. Cashin has filed several motions, and so a couple of things that I feel like we could probably handle today, and then a few things that I'm going to put off to another day. Most of those motions, I think, were filed Friday.
Yes,
Mr. Smith is the Assistant District Attorney on the case. You can talk with Ms. Malfino this morning. She'll kind of fill you in on how I guess let me go through the first thing with regard to discovery.
Yes.
And how you get that here. There's a portal. It's very easy. The state is very easy to deal with. They'll give you access to that portal. If there's any media in the case, there's a different request that needs to be made for that. Ms. Malfino can sit with you this morning and explain how all of that goes.
Yes.
So with regard to it, this time discovery, I'm not going to rule on any discovery motions. It's automatic. It's with Michael Morton Act and everything else makes it where they're going to give you everything they've got.
Yes.
And so if you find after you visit with them and you get everything off the portal that you feel like there is something that's missing, then bring it to my attention, bring it to their attention first, obviously. And if there's an issue that you feel like you're entitled to something that they're not turning over, then we can have a hearing on that at that time. So the next thing that I do want to go through and rule on, at least today, is that motion for a gag order that was filed some time ago, and so everybody's had a time to take a look at that. I'm going to, Ms. Malfino, I guess let's start with you. Obviously, I understand Mr. Cashin's position with regard to that and his motion. What's your position?
I do as well, Judge, and I think the court is aware, as long as you've known me, myself and Mr. Smith, it's always our best practice policy not to speak to the media or anybody while a case is pending. If that, I have no objection to that order, and if it is granted, I will be sure to send out a memorandum to my office,
Yes.
letting them know it has been granted and that they need to comply.
Sure. And I don't have an issue with the district attorney's office. The only issue that I have is the sheriff's office.
Yes, ma'am.
Because I don't think the sheriff, typically, as everybody knows, gag orders are not deemed constitutional. Obviously, there's exceptions, and Ms. Malfino agrees in this case with regard to her office.
Yes,
I will gladly ask the sheriff's office, but I don't think I'm in a position to order them. They are not a party, as the attorneys are, and so I'll let you make argument if you'd like, but I'm not inclined to grant a gag order on someone that's not a party. I don't think constitutionally I can do that.
I understand, but I just wanted to point out to the court that certain people in the sheriff's departments, I think they have podcasts and they go on the media and then they give their opinion about this case that is presently pending, which I kind of think taints the jury pool if we end up in a trial. And
Do you know who that is? Somebody who has a podcast currently about this case?
Well, I've seen sheriffs speaking about this case on different broadcasts. If I need to be specific, I will locate that particular.
If you don't mind doing that, and you
Yes,
can,
ma'am.
if you would, you can just email myself and Ms. Malfino, Mr. Smith, because I don't mind at least starting with a request to them not to do it.
ma'am.
If I feel like what they're doing is in some way going to be detrimental to us being able to get a jury,
Yes, ma'am.
then I will look more into that. I don't know, again, the constitutionality of it. I would have them probably show up to a hearing with their legal representatives and we can handle it that way.
Yes, ma'am.
So let's do that. At this point, I'll grant the motion in part with regard to the district attorney's office and obviously with regard to you, Mr. Johns, and anybody and everybody's, y'all's respective offices. And then send me that and whatever information you can find.
Yes,
I'll
ma'am.
talk to the sheriff's office. I have a feeling they won't have any issue with my request. And so, but if they do, then we'll talk more about that. So then that's that.
Also, Your Honor, I think, which, some housekeeping matters that I think are rather important is in regards to the indictment and the way the indictment.
Yes, so you filed a motion to quash the indictment. I did take a look at that. I honestly saw the same issue already with the indictment.
Yes, ma'am.
The style or the heading of the indictment
Yes, ma'am.
legally is not necessarily indicative of the most important part, or it doesn't, what's the word? The body of the indictment sounds correct in this case.
That is true.
The state has become aware of that. It should say A2 instead of
Yes,
A10.
ma'am. Yes, ma'am.
They are going to get that taken care of, and so that way it looks correct. It's correct, obviously, in our system as well, which can become an issue just because of our system.
And I just want it to be correct for the.
I
for the
totally
nature of the
agree.
charges.
And that's the only issue, was the A10 to A2, correct?
Yes, ma'am. That's-
Okay.
Yeah, that's rather important.
It is. The body, though, I
It's
did read the
fine.
body, and it looks like there's not an issue, but we'll make sure that the, Ms. Malfino,
And Judge, having not worked with this gentleman previously, I would be happy to make an oral motion to amend if you would prefer.
It
That
doesn't
we
matter.
follow that up with a written motion, just so it's cleaner for the court.
I think I'd rather,
just
just because of the nature of the offense,
Sure.
because it's a capital, if we just do that, if y'all would do a motion in writing. And that way, we've got a paper trail
Yes,
in the file that shows there was a motion that's and I'll grant that and
Yes.
make that adjustment on the
I just
indictment.
want it to be accurate.
I don't disagree with that at all. So they'll get that taken care of, I'm sure, very soon.
It's gonna be e-filed, sir, so
Okay.
if we can exchange emails,
Yeah,
I can
fine.
be sure
We'll
that
do
it's
that
served.
after we conclude.
It looks like the other things that were filed have to do with, mostly discovery issues, a list of persons to contact or interview, some
Yes,
things
and
like that.
That to me, Your Honor, is important because after reading the probable cause affidavit that's attached, it indicates a lot of, he said this and she said that, and
That's one of those things that I would say, get with the district attorney's
Yes, ma'am.
office. Obviously, I would think anyone that any detectives or officers talk to or interview
Yes,
would
ma'am.
be part of required discovery.
and I would like that, kind of like early on instead of later on, because those people
Well,
need to be interviewed.
Sure, I mean, whatever they have, you'll get.
Thank you.
And then if there's anything, again, that you feel like is not included,
I will.
bring that to their attention first.
ma'am.
Let them contact the agency,
Yes,
see where that stuff is and how quickly they can get it. And then if it becomes an issue, let's get back on that.
Yes, ma'am.
The last thing that I see that I'm not there's a motion for preservation of personal notes.
For the officers, the police officers.
Okay. Ms. Malfino, have you had an opportunity to take a look at that? I really haven't, as far as,
Really haven't, Judge. I know that.
I would think
you know,
personal notes might fall into some type of
of
work product. I mean,
Yes.
their reports
if
obviously
something
will
was
be turned over.
exculpatory, yes, I would agree that, that information be turned over. I would assume it would have then been placed into a report.
Right.
At some
Mr.
point, I
Cashin?
would argue that some of that is work product, personal notes of correspondence between us and the officers in preparation, et cetera. I would argue is work product.
To me, the personal notes are attached to the people that have been interviewed, because the officers, when they go out and interview people, they may take personal notes, because in the probable cause indictment, it said that they had spoken to certain people who said that he had a gun on a particular occasion, certain people that said he did it, and those are the people that need to be interviewed, and the personal notes of the officer relates to those things.
And Judge, if I may, I think he may find when he requests the media that majority of those interviews
On
might
body
possibly
cam.
be on body cam or having someone come into the police department.
Right.
It's not so common practice anymore for the transcript, so to speak, of that interview to be recited then in a report, so it may reflect in the report, I spoke to X, and he hasn't seen the recorded interview, which would obviously make a big difference.
Okay,
But that's the type of information I was leaning towards.
sure, and I think that's probably, let's do
And
this.
with the nature of the case, I need to cover my bases.
Absolutely, no, yeah, I would totally agree. So today, what I'm going to do is hold making a ruling on the motion for preservation of personal notes. The motion for discovery, obviously,
Yes,
that's
ma'am.
granted, you
Yes,
get,
ma'am.
you get all of that, work with them. Anything in the person's interviewed, let's go through the discovery
Discovery,
process
yes,
first, the way, if there's anything, if there's anything that comes up that you feel like you're entitled to, that they are refusing, then we'll have a hearing about that and work that out. The last thing is there's a motion to reduce bond that
Yes,
was
ma'am.
filed on Friday.
Yes, ma'am.
And so, Ms. Malfino, I'm gonna ask, is the state ready to proceed on that today, or do you need some time, or to get Mr. Smith available on that one?
Well, and I'm happy to cover it, Judge. I don't need a lot of time. I would prefer the ability to get at least the lead detective here for the court.
Sure.
In the instance that you or counsel would have any questions with respect to that. I'm not necessarily saying we're opposed to some type of relief. I know what the bond is set at now, but I think due to the nature of the case,
Sure.
as counsel has stated as well, I think it might be beneficial to have just a very short hearing. I can be prepared on that as early as next Tuesday, Judge.
Okay, so Mr. Cashin, we can do a couple things. I think just because it was filed kind of late in the game,
ma'am.
I want to give them just a short amount of time
Yes.
to get prepared on that. We typically have Tuesdays are our jail dockets. I'll be in,
Or maybe the next week, since we're gonna be in trial next Tuesday, we won't the following week because of Labor Day.
Right.
That would be great.
Mr. Cashin, I'll let you choose next Tuesday or the Tuesday after.
Let me get on my calendar right quick.
We could do it next Tuesday. Do we have one already set at 11 next Tuesday? We'll do a lot of these types of things at the end of our Tuesday dockets. We might have something already. We do not. So we could do it either or next Tuesday or the Tuesday after.
Tuesday afterwards might be better, September 2nd.
September 2nd?
Yes, that'll work better for me because I have several matters next
Sure.
Tuesday.
Okay, then we will set the motion to reduce bond on the 2nd. And if anything comes up between now and then, we can discuss all that as well. And especially if, Mr. Cashin, if something comes up after I visit with the sheriff's office with regard to any information that you emailed to us,
Yes, ma'am.
then we can maybe have them here on that day, possibly
Okay.
to take care of that part. But right now, I am granting the part of the motion for gag order on the attorneys only.
Yes, ma'am.
Okay? Anything else we need to handle today?
I think that covers
The
it.
status of my case with him, prior to these new allegations, we had come to a proposed plea bargain agreement with Ms. Smith.
I won't, at this point, I don't think it's appropriate for me. I'm not going to accept any plea agreements
I
on that
understand
case.
I'm just kind of giving you the background.
Sure.
Let you know, I have been talking to Mr. Smith. I talked to him last week in reference to this case, some of the suggestions that he made to me. I really don't know where to go forward with this situation, so I would ask for more time, so I can see what's going to.
I
this
think
case.
that, sure, and I think what we'll do is carry the two, they're obviously not on the same date, cases, but they're related. And so the cases will be carried together on all of the dockets. And if, on next Tuesday or the Tuesday after, that's really a motion that Mr. Cashin has filed that we're going to handle. If you want to be here for that, you're welcome to. I don't think legally you haven't filed anything that we would be hearing on that day. It would be the bond reduction. But typically on announcements and as we're preparing to move forward in the case, I would expect you both to be here. Both cases will kind of travel together and then we'll see where we get.
To add to that, I appreciate you saying I don't have to be here next Tuesday. I'm at a stage in my life with my mother. I'm blessed to have my mother at 94 years old. And you probably can make an anecdotal effect that I'm pretty much steady going to be in court when I'm supposed to be in court. But because of that, I'm having some issues and I'm not getting where I need to be getting it. The secretary's gone. So I'm having a few,
Well,
few little anecdotal issues right now, which I
Right.
haven't had the last 30 years.
We'll make sure, again, on the second, you don't need to be here
Yeah.
on that one. After that, you'll get notice of obviously every announcement and things like that. And so, if you're having an issue, just let us know. If it's something that's just an announcement, it may be something that you can visit with Mr. Cashin. If there's nothing that's taking place and you're having an issue, we can still move forward, at least with moving the cases along. All right.
Thank you, Your Honor.
Thank you.
And that's one other thing that in reference to discovery issues, the discovery portal is absolutely fantastic dealing with. But these TFI files that they file instead of using the PDF files, they change were almost impossible to open them. Okay?
All right, so I don't know the letters you're saying, but get with Miss Malfino and Mr. Smith.
She can't fix
Anything, I'm sure that if there's, I'm sure if there's any issues that you're having with a specific file, they'll get that for you. Just get with
I
them.
don't know if that's possible. They might have to go upstairs to the computer department, but thank you, Your Honor.
All right, yes, sir. Thank you, Mr. Cash, and Mr. Williams, you can go back with the bailiff.
Excuse me.
Yes, sir, nice to meet you. All right, sir, are you Avion Johnson?
Yes, ma'am.
And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
So no corrections, but there is an issue. Ms. Malfino and I have spoken about this. On page 2, at the very top where it says restitution issues, it looks like there's an outstanding bill, if you will, for repairs in the amount of $150,000, but I don't know if that's the actual case. I think that those,
And I would agree, Judge, if I may, Lori,
Sure.
that figure came from the fire department, not from the apartment complex.
Okay.
The apartment complex may be under governmental control, and that may have taken care of the issue. With
Well-
respect to what Marshall Ertl said in the PSI, I know him very well, actually, and he didn't understand some of the predicament I was in with respect to the complainant, that I had let the court know in advance about her mental status and cognitive ability to testify, etc. If you would like me to take a deeper dive into where that restitution is owed, if any, that's obviously way substantial amount to order Mr. Johnson. I am concerned about his behavior.
Well,
while awaiting
I'm
sentencing.
concerned about his behavior, but I'm just as concerned about the fact that he,
He
denied the
denies he learned it
offense.
on her, right?
yes.
so if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than that's obviously not arson, that's an accident. And so we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, or not. So did you do it? Did you not do it?
No, I wouldn't say I did it, but I would say that I contributed it to it. We were kind of wrestling, and it just happened.
Again, that sounds like an accident, not arson. Because here's the thing, I mean, a 5-year deferred probation is a great deal. I mean, you don't have, well, I say that, you do have criminal history and a revocation. So I don't know. Anyway, if you violate your probation later and you're back in here on a motion to revoke, it's a first, right? I mean, you're looking at 5 to 99. And if I say, you know what, I think you deserve 25 years in prison, you can't say, well, I didn't really do it back then. I shouldn't have pled guilty. So you're stuck. So either you did it or you didn't do it. you know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said, you're gonna tell the truth. And so telling the truth is either accepting responsibility if you did it, or saying it was an accident. And if it was an accident, it's an accident.
But I pled out to it, I pled guilty to it, and I accepted the charge for arson. I understood what I was doing, so.
Okay, all that's great. Did you do all of that because you're guilty of the offense?
Yes, ma'am.
Okay, so I guess what we need to do, at that point, then I don't mind. The only problem is I need to have that restitution before sentencing.
Yes, ma'am.
But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be, if I may, Judge, to order not to exceed that amount. I will confirm, and then we can
Sure.
drop it to.
You've done that before.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that, though. I mean, that would,
If you understand my position
Sure,
of what I'm saying
absolutely.
about where
I
it
do.
was.
Yeah, and then if you, if there's an issue when the restitution amount, if any, comes out, and we need to have some type of hearing on that, then we can still do that even though he's sentenced, if I do a not to exceed amount.
Yes, ma'am.
So do you understand, Mr. Johnson? What I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe, who knows what, maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation, so it's really important that if there is any ordered, that you start making payments on whatever it is, every single month, even if it's just a little bit, to show me that you're making those payments, okay? So what I'm gonna do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your jail incident reports. You know, I mean, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking that the correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really? You think that's where you're going to meet your next girlfriend?
No,
Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were gonna beat his ass.
can I say something a little bit?
I don't know, you probably shouldn't. How old are you?
I'm 32 in this year.
You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about, all of them that are out there acting like heathens. That shouldn't be you. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in their 30s. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, you get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm gonna look back at that time and see that I gave you an opportunity on probation when you just revoked a probation 2 years ago. And so it's probably not gonna be some little mountain prison and you just get to go on your way. It's gonna be, you need to start learning from your mistakes kind of thing, right? Make sense? All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is go to probation, okay?
Yes, ma'am.
All right, good luck.
Thank you, Judge.
Thank you. Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25 DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than something I'll clear up on argument.
Okay,
I have nothing, Judge.
go ahead.
Well, Judge, when you review the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems that he was minimizing or still deflecting some of his responsibility in what happened. I did speak to Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was 2 people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood, and so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation where someone was underage or anything like that. She was definitely of the same age. Being in a relationship with him, they started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they were together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001. So since he was in trouble that one time, or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of his family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of him. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in this situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court to consider deferred adjudication in the situation with Mr. Ardwan.
Thank you. Ms. Malvino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, but the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap, but defer to the court's discretion, of course.
Thank you.
And if I just may confirm, in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I
we
think
did
we
that
did
at
that at
the
the
plea.
plea.
Okay,
Mhm.
just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Malfino that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point, where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years, there's no treatment, there's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is a probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years, or I violated and I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Now, obviously, a part of this probation is that you have absolutely no contact and no communication with the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand?
Yes, sir.
All right, good luck. Thank you, Mr. Lewis. Sorry, that goes with that. He said, how are you doing?
Oh, yeah.
Good morning, you're Kevin Ross.
Yes, ma'am.
And so Mr. Ross has two motion to revoke probations, cause number 24, DCCR 1198, on probation for the offense of a deadly weapon in a penal institution, and in 24 1199, evading arrest or detention with the use of a vehicle. Mr. Burbank has filed motions asking that I set bonds in these cases. Give me just a second to get this pulled up.
Judge, if I may, just
Yeah,
to
go ahead.
inform the court, we have discussed this at length, Mr. Burbank and myself. I have made several requests to DPS via my investigators to bring the new evading. Typically, we could proceed on a motion with just a probable cause affidavit. The alleged egregiousness of this evading lends to an absolute need for the video, which is what Mr. Burbank wants. Considering DPS has not brought that, I feel like in fairness, I cannot oppose a bond for this defendant, because I think that the video itself will be dispositive of either he was driving or his brother was driving, is my understanding. I've made requested the trooper, and they just haven't brought it in, so June 13th, that's the date.
And if I may
Can't
add,
imagine why it would
Judge, I
be.
will represent to the court, I do have an affidavit from another individual, but I need the video, because we could really shortchange, get right to the point.
Who's the trooper?
CJ. And I'll try to reach out again.
I'll reach out this afternoon after docket. So I'll figure, it looks like there are other allegations,
I'm sorry, Judge.
and so,
Garcia. Jordan Garcia.
I'm sorry.
I had Jordan Garcia, I had seen Judge said no, on my line.
In addition, Your Honor, Magistrate Court,
Yeah,
in my motion, I also asked if you would consider a bond, some other requirements that I believe would be necessary.
And I've spoken with his probation officer, and she understands the situation.
so we've got allegations of the evading with a vehicle and just an evading on June 13th. And then possession of marijuana from June 13th as well. And then drug patch, tested positive for cocaine. Out past curfew, June 13th at 1:39 a.m. Okay.
I have the PC on that today, Judge, if that would help.
I think I might have it right here. Let me take a look at that as well. Here's what I'm going to do today. I'm going to hold the motion to set a bond. We're going to, I'll contact DPS as soon as docket is done to see what it takes to get that video. If we can get it quickly, then everybody can look at that and see where we are. If for some reason we cannot, then I will reevaluate and set bonds at some amount based on the nature of the allegations and all of that. So,
And I'll
but
have, Mr. Bates reach out as well, Judge.
Okay.
This morning while you're on the bench.
Okay.
They can get it.
if you'll let them,
When they know the court is.
if, yeah, if Detective Bates will let them know that he's gonna call them or I'm gonna call them, so maybe they can get that very quickly, and we'll go from there. All right, go back with the bailiff. At the most, we'll reset it for a couple of weeks, but if we get that, then we'll figure it out as soon as we have an answer today. I'll get with both of you. Okay, go back with the bailiff.
It's mandatory, right? But not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea,
Yeah,
Right there.
and then
what's all this?
defamation, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going on and try to stay out of trouble. They all up on the microphone.
All right, this is, stop talking. This is cause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, let me go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again.
My apologies.
Who's in here for him?
My grandmother.
All right, ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you?
I apologize. I
Saying you're sorry doesn't matter.
Christian, man.
This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay,
And I've been trying my best to stay out the way. I've been getting bullied over the microphone. I have inmates there encouraging the inmates to harass me, calling me punks, alpha, profit, you know, plenty of things. Gangster player, mad,
yeah,
mortar. Man, I'm just trying my best to stay out the way.
okay,
I got a job, I got a home, an actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. And my dad's 76 years old.
yeah.
My best to stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room.
I work out.
Who made
I'm a
you do
boxer.
that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room? Yes, ma'am.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm not running freely throughout the facility or anything
Uh-huh.
like that, but I do work out a lot every day.
So are you, who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you dash the floor with water?
I'm not the only one. That was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah, but
right?
it wasn't
Nobody's,
like that.
stop talking when I'm talking. I'm gonna ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the cell all day long, man. When I see them women, I get flirting. I'm a lover boy. I admit that.
'Cause you're a lover boy.
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When
Oh, yeah?
you're dealing with these stressful inmates, you know what I'm saying? I love to be around mama.
Okay,
I'm a mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
yeah,
I've got to call into the investigator for the sheriff's department to find out
okay.
when they'll bring that over. But I would ask that we go ahead and set these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is gonna know about all that. You understand that? Okay, and do you think that's gonna help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think, let's go through real quick before we do this rejection. And cause number 24-1500, you're charged with obstruction or retaliation. Is that a third?
That is a third, Your Honor.
Third-degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? And cause number 24, DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second-degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that?
Yes, ma'am.
And cause number 24, DCCR 1615, you're charged with aggravated robbery, which is a first-degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand? And then in 250436, you're charged with burglary of a habitation, which is a second-degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand?
Correct.
I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 10-year term in prison on a lesser offense of robbery.
Of robbery and dismiss all the other charges.
You have every right to reject that.
It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide, because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
are all these charges gonna be on one trial?
They don't necessarily have to be, because you've
Your
got
Honor,
3 different dates.
Your Honor, the robbery and aggravated assault are the same offense day. I'd expect to try them together.
Okay, so what can happen is you will, it sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand? Okay. All right, we'll get it set for trial. Go back with the bailiff. Good morning. Are you Carrington Scott?
Yes, ma'am.
And this is 25 DCCR 0538. Mr. Scott's charged with robbery. Mr. Burbank?
Your Honor, I have reached out to Mr. Smith. I understand what's going on. There is a video that is missing, and he was attempting to try to get it. The court could do 2 things. It would probably be dispositive of this case if it received, it's a convenience store robbery, and some of the cameras were missing,
Okay.
the tape. If you want to reset it for a couple of weeks, I don't know when Mr. Smith will be back.
I'm sure Ms. Malfino or Mr. Nichols can
We
step
can
in.
handle
And
it, Judge, and I just want to let the court know, Mr. Smith has documented that he did reach out to the detective on August 12th. I'll be happy to follow up.
Okay, thank you, Ms. Malfino.
It's a
So we'll
missing
just,
convenience store video. Some of it was already erased, so I agree it would be dispositive.
okay.
Be dispositive of it. I mean, he's rejected the 15 years from Mr. Rojas, Judge.
All right, we'll just do maybe about 3 weeks. That'll give Mr. Smith, when he gets back, or Ms. Malfino, sounds like she'll step in and try to take care of getting whatever information they can, so that we'll, if they have it, you can see it. If they don't have it, then we'll figure it out from there as well.
I'll do it.
All right, thank you, Ms.
I'll be
Malfino.
happy to see you, Mr. Scott. I think that's all I have.
It is. Thank you, Mr. Burbank. Good morning, sir. You're Jesus Ibarra? And this is 23 DCCR 2253. Mr. Ibarra's case is set for trial to begin with jury selection next Monday. And what is the announcement?
We'll be ready, Your Honor.
Right.
State's Attorney.
All right, I want to go make sure, let's see, what was the previous, has there been any other negotiations or offers?
It was a cap of 8, Judge. I did let Mr. Jeffries know in docket yesterday before he met with his client that I was open to having further discussions. It's my understanding that it doesn't plan.
All right. So I want to make sure you understand, Mr. Ibarra, it's likely your case will be the number 1 case for next week, and there will not be any plea agreements accepted after today. Do you understand?
Yes, Your Honor.
All right, and so you want to still go forward with your trial next week?
Yes, Your Honor.
All right, we'll see y'all next week. I will number the cases and let you know after docket, but I anticipate this will be the number 1 case.
Yes. I may ask if I could get maybe a protective order. I'm on a trial docket in Polk County as well, not number 1, but I'm there.
We'll get that done as soon as it's numbered after docket. We'll get you protection so that you're here, since your client is it anything older or a kid case or anything like that up there? Okay, all right, then we'll make sure and take care of that so that you're good for next week.
Thank you, Your Honor.
Thank you. So just make a note to get that. All right, are you Jacoby Frazier?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Frazier, in cause number 25 DCCR 0732, you're charged with the third-degree felony offense of obstruction or retaliation from May 18th of 2025, and how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily?
Freely?
Okay, did anybody force you to plead guilty?
Uh-uh.
All right. I have here on the computer some documents that have your signature on them that it looks like you went over with Ms. Holmes. Did she explain those documents to you before you signed them?
Yes, ma'am.
And do you understand those documents?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred probation.
With 5.
There's 4-year probation and then a $500 fine. Does that sound right?
Yes, ma'am.
And you understand as long as I follow that agreement, you can't change your mind later,
Yes, ma'am.
okay? And are you a U.S. citizen?
Yeah.
Okay. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Frazier is not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give us more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's?
I have no
Position.
objection, Judge. He has one misdemeanor evading. I think the PSI will probably come back and show us all maybe some specialized caseload.
Sure. So, Mr. Frazier, if I reduce your bond, where would you go live?
6655 Ave Street in Groves, Texas.
Who do you live with there?
My grandma and uncle.
Okay, so here,
Actually, grandma owns the house, but she stays there most of the time.
okay. So do you have transportation to go to probation
Yeah, I
and
have
things
this
like
lady
that?
named Miss Charlie. She works at Motiva. She had brought me to court, but tell me to come back, but I didn't come back. But she'll bring me.
Okay,
And I cut grass. I have my own lawnmower.
good.
Weed eater, I couldn't use it, so I gave it away for free.
Okay. I don't want there to be any issues with showing up for the pre-sentence for that interview, so I'm probably gonna leave everything the way it is so that we have a good plan in place with that pre-sentence report, and then that way, hopefully, there won't be any issues and we'll have all the rules in place, okay? So I'm gonna leave everything the way it is now. We'll see you back here in just a few weeks, and then at that point, you'll get out and be on probation, okay? All right, go back with the bailiff. Good morning, are you Robert Eaglin?
Yes, ma'am.
And this is 24 DCCR 2382. Mr. Eaglin's charged with aggravated assault with on a family with a weapon, and case set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, the state needs to announce not ready. I have spoken twice in the last week or so with the complainant. She had a stroke. She actually called me from the hospital.
Okay,
Tell me that she had just had a stroke. She has to do some therapy to be able to be in a position where she could clearly testify. She is cooperative. She understands the ramifications. She's checked in again yesterday, nervous about what my announcement was going to be. The court will see that case. The offense date looks a little bit older. It was originally in CBC. Mr. Laird had it. They could not locate her at some point. It was then dismissed. When they did locate her, when she saw something on the news or on social media, it was refiled, it came here, so it's actually just been through maybe a setting or two, and this is a first trial setting, so
Okay.
I would respectfully ask for a continuance to allow her to rehab and then be able to.
okay. I will grant that, and we'll reset it to the next available trial docket. If there's any issues or motions that need to be filed before then, just let me know.
Okay.
Okay?
No problem.
All right, you can go back with the bailiff. If there's a new, I'm inclined if there's a new offense that has been indicted that's not in the motion, I would think would there should be maybe an amended motion that comes so that
Maybe
we can
so.
go ahead and include that in
There
everything?
was an email, Ms. LeBlanc from probation followed up with Hardin County, and they stated that they, as of June 30th, had not filed anything further pending, which you can read either there's nothing pending or there's only one thing pending. So it's a drug case, so I don't know if they're saying, well, it's not pending because we don't have a lab back, but I'll.
But you think it's been indicted now?
Yeah, she said in the email, she said there's one, she was indicted on March 27th for a second-degree felony possession. That it was set for court in July, but that offense differs from the offenses listed in the MTRP.
Okay,
So the offenses on the MTRP have not been filed.
but there is one that
But there was
has.
one that was indicted in March.
Okay. I feel
It
like,
makes sense because the ones in the MTRP are from 2004 and the March is
24,
2025. But it's
yeah.
hard to-
so what let's just do, I'm gonna reset it one time. Ms. Malfino, if y'all will get an amendment done, just so that when there's pleas of trues or not true, it's to everything that's out there and there's not any question. I mean, if the other ones aren't coming that are old from 2024, that's
24.
fine, but if we've got one indicted, let's go ahead and get it in the motion.
And I know last time she had been hesitant to go to treatment. I will reach out to them and ask if that's something that is ordered, that would concurrently take care of
that.
cases
Okay.
as well.
That would be great. Thank you. All right, we'll get all that tried to, so everything kind of happens at one time, hopefully. Okay? All right, go back with the bailiff, please.